Welcome to our fourth and final lecture relating to Chapter 24, which is the chapter that covers employment and discrimination law. I think, as I might have said on the first lecture, that this name for the topic is not really what people in this industry would use. The people who practice in this area call it labor and employment law, and we are about to get to labor. So the second half, or the other half of that topic, we're going to touch on, but we're just going to not even graze the surface of this area of the law. We're just going to kind of introduce a few ideas about it. So let's get started. Let's just do a little review of where we've been. We've talked about at-will employment. We've talked about the three big discrimination laws, Title VII, Americans with Disabilities Act, and the Age Discrimination and Employment Act. We talked about the different discrimination theories that a plaintiff can advance: disparate treatment and disparate impact. We talked about sexual harassment. And we talked about BFOQs and bona fide seniority systems. We talked about the EOC charge process. And then we talked about individual employment rights statutes, such as the Fair Labor Standards Act, which establishes the minimum wage and the overtime characteristics of that benefit. We talked about the Family and Medical Leave Act and unemployment compensation, as well as COBRA and ERISA and OSHA. Privacy, especially as it relates to electronic monitoring and polygraphs. We also very briefly touched on USERRA. And now we're ready for labor law. I took 2 courses in law school just on this topic, and so there's just so much to talk about and so many interesting aspects of this law that I really feel like it's almost a disservice to talk about it and not get into more details, but time is scarce, so we're going to do just a brief touch on some big themes. I will start by saying that I think most labor and employment attorneys find labor law the most interesting, the most intellectually satisfying part of this area of the law. It is incredibly interesting and thought-provoking how our system addresses the balance between individual rights and group rights. Reasonable people can differ on where the line ought to be, but it's just a very interesting topic. So we'll see a little bit why people in this field enjoy the field so much. But it is a very complex field, at least as complex as everything else we've covered, and probably more so. First idea we'll talk about is Texas and its status as a right-to-work state. There are kind of 2 categories of states with respect to union issues, and about half the states are what are called right-to-work states, and about half are union security states. Generally, states in the southern part of the country are more likely to be right to work, and states in the northern portion that typically have a higher rate of unionization are more likely to be union security states. So you could say that these are more anti-union jurisdictions, and these are more pro-union jurisdictions. The name itself, right to work in union security, is a little bit like when people talk about abortion issues and they say pro-life and pro-choice. Those are nice kind of spin terms, but they really don't tell you very much about what the perspective is. Similarly, these terms are really about selling a particular ideology. It doesn't really explain the ideology very well. So if you're like most people, when you hear these terms, you're like, I'm not sure. I like the idea of being able to work, but I also like the idea of being secure. So I'm not quite sure which one I'm supposed to favor and what are the advantages and disadvantages of both. So let's go through and make it clear what these terms are talking about. One thing that people often confuse is right to work with employment at will. not related to employment at will. Imagine for a second that you, let's think about this in broader terms. So let's assume, we'll talk about how this would happen, but let's just assume for a second that a group of workers have organized and they have selected a union to represent them, and they've jumped through all the hurdles, and it's now official that this particular union is representing them. And this union is now negotiating with the employer to establish the terms and conditions of the employment of these particular workers. And we won't yet talk about exactly what's involved in that process, but just assume that that process is ongoing. Well, the union says to the employer, we are concerned that some of the people in this unit, we won more than half of the votes, but some of the members of this group of workers aren't that excited about us. We think they're mistaken not to be, but we're not sure that all of those individuals will be willing to join the union. And we need to have that income because, we're going to be required to provide services to these individuals because we're representing them, and that costs money. We'll have to have union stewards. We'll have to sometimes hire attorneys for them when there's disputes with respect to the employer. So we really need to figure out a way to force, or to at least strongly encourage, the workers in this unit to join the union and therefore pay union dues. By the way, union dues are typically the equivalent of the hourly rate times 2 a month. So if you earn, say, $12 an hour, then you would pay $24 a month in union dues. But it doesn't have to be that way, but that's a pretty common equation. Okay, so the union says, we want your employer, we want your help in making this happen. Well, the employer's first reaction would be, why should we help you? That's your problem. That's your relationship with the employees. We don't really have any particular agenda here, whether the employees join the union or not. It's no skin off our nose. Well, then the employer says, but you know what? There are things that we would like out of this contract. And so we know something you want, and there's some things we want. It sounds like we might be able to come to an agreement. You give a little, we give a little, everybody gets a little, everybody gives up a little. That's kind of how you negotiate any kind of contract. And so the employer might say, we're willing to enter into an agreement with you that says that that employees have to join the union in order to maintain their employment. We're okay with that. Wouldn't be our first choice, but you don't always get to have the things you want. But in exchange for that, we're going to want to perhaps have a smaller wage increase. Maybe we were planning on doing a 25-cent an hour wage increase, and we are thinking now we'll just go for 15 cents an hour. It's a trade-off. You get something, you get a requirement that all of the employees have to join the union to maintain their employment, and we get to save a little bit of the cost of wages. And then, of course, the union will have to choose, is that a good decision for us or not? Let's assume for a second the union says, okay, we think that's a fair trade. We're getting something, you're getting something, everybody's happy. Maybe not the workers, but everybody else is happy. Anyway, so they go through all the other terms, the benefits, the paid time off, the general description of who does what type of assignments, what the grievance process is like. I mean, it's a really thick document, but there's a lot of things to go through. And so now the union signs the contract, the employer signs the contract. It is now the terms and conditions of the relationship between the employees and the employer. Well, this particular work group has 100 workers, and 60 of those workers voted in favor of the union. So now it is time. Now there's a contract. The union is going around to those 100 workers and saying, okay, now it's time for you to join the union. We have this contract. Oh, look, you're going to get 15 more cents an hour than you're currently enjoying. So this is a good thing for you. So please sign on the dotted line. several of the employees are excited about it. They were excited about unionization, and they are delighted to join the union at this point in time. We'll say that that's 40 of the 100 people. There's, maybe 20 more that after some encouragement and campaigning, they get pretty excited about the union. They're willing to sign on the dotted line too. But there's, we'll say, 35 or 40 folks who say, nope, not going to sign it. I don't want to give you 2 hours of my work. I work hard for those 2 hours, and I don't want to give you that money. Plus, 15-cent wage increase, that's not much. I'm not impressed by that. I don't think you did that great of a job negotiating. And so those 35 or 40 are not willing to sign on the dotted line. If they don't join the union, obviously they aren't required to pay union dues. So then the union, after having cajoled and encouraged and done those tactics, finally says, okay, listen, this is what the deal is, fellas or women. You have to join or you're going to get fired. Those are the two choices. The employer has agreed that it will fire anybody who 60 days after this contract has not joined the union and has not opted to have the union dues withheld from their paycheck. So now those 35 or 40 employees have to make a decision. Are they going to sign up for the union and sign up for that automatic deduction of their dues, or are they going and continue their employment? Or are they going to resign and go find another position? And of course, the decision that those 35 or 40 workers make is going to partially turn on what other career options do they have. I mean, if there's lots of openings in that particular market, they may well say, goodbye, I've found a better job. But if jobs are relatively scarce or this job is a relatively high-paying job, they might say, well, okay, I prefer not to, but since I don't have a choice, I'm going to sign on the dotted line. Okay, so you can see in this situation, the union and the employer, through the collective bargaining process, can establish union membership and dues payment to the union as a condition of employment. States that have that practice or that permit that type of contractual provision are called union security states. And you can see why you would call them that, because the union has some level of security. Obviously, the union is, in some sense, a business. You can see it maybe as a little bit of a charity, but it's also, a business. And its customers are the members of the union. Imagine if a theater chain allowed, took tickets from some of the people who are going in to see the movie, but routinely lets other people just sneak in. And in fact, half or more of the people who attend a movie screening just sneak in. Well, what you'd start finding is that some of the people that had in the past been paying will stop paying. I mean, after all, why should they pay if other people get to sneak in? And over time, more and more people will be sneaking in and they won't be paying. And then eventually the theater is going to go bankrupt because they aren't going to be able to meet their expenses if they're not getting much in the way of income. Similarly, a union could fail because there are costs associated with running a union, and if no one's willing to pay the dues that essentially are the union sales, then the union's going to fail. So there is an argument for union security states. It lets the union be fiscally sound, which allows the union to continue to successfully represent the employees. But there's also an argument for right-to-work states, which is again what we are in Texas. And this is the idea that a person should not be required to join another organization or to pay fees to another organization as a requirement to retain employment with a company. After all, of those 100 workers, 40 voted against this union. And those 40 are now being required to join that union in a union security state, even though they voted against it, even though they don't want the union to be in that facility. And so they can say, well, I don't share the political views of that union, or I don't feel like the union negotiated a very good agreement, so why should I be contributing to its financial well-being? or I don't have a two hours of extra pay. I can't afford to have those kinds of deductions. So there can be all kinds of reasons that people feel like that they don't want to pay. And so in Texas and other right-to-work states, it can't be a requirement that a union can insist upon in a union negotiation that the employer require that the workers join the union. You have a right to work whether or not you join the union, even when your workplace is unionized. So you can see how, as a result of this policy, whether you're in a right-to-work state or union security state, this has a pretty major impact upon the likelihood that a union will try to organize a particular work environment. Because in Texas and other right-to-work states, even if the union is successful in organizing the unit and becoming the representative of those workers, there still may not be a lot of money in it if many of the workers choose not to join the union. If they don't choose, they can't be forced. And again, that free rider problem, that issue that where somebody can sneak into the theater and see the movie without paying, is a reason that the union says, well, this isn't as profitable an area for us to organize, so we're going to concentrate our resources on union security states, which, if we are successful and we win the union election, we can negotiate so that that particular employer can agree to having a union security clause in the contract. Now, it's important to keep in mind, even in union security states, that the employer never has to agree to that. So this is just one of the subjects of negotiation. We'll talk a little bit more about that later. As a practical matter, employers almost always do agree to union security clauses, but they don't have to. So let's go to the next component. So we've talked about how right-to-work states function. We've already talked about the fact that Texas is not heavily unionized. Over the last 30 or 40 years, there's been a significant drop in the percentage of the workforce that is unionized, especially in the private sector. Government unions haven't declined at nearly the same rate, typically because the government entities usually take a neutral stance in union elections. So it's quite a bit easier for a union to win an election against a governmental entity. That is kind of the reality. I think we'll expect those numbers to continue to decline. There are a few industries that are more unionized. For example, the airlines industry is fairly unionized. The automotive industry is fairly unionized. But outside of a few niches, there's not a lot of union activity in Texas. The statute that we'll be looking at in this presentation is the National Labor Relations Act, which is usually called the NLRA. This was the first law that was passed in this area that really set up a schema for the whole labor system in our country. There were several amendments to that statute. You do not need to know the names of the amendments. It's interesting, though, from a historical perspective, to see what those amendments were trying to address, what concerns they had, because they really are almost a blueprint of what the issues that were going on in the larger culture were at that time. Sometimes amendments were designed to to protect employees against unions. Sometimes they were done to protect employees against employers. Sometimes they were done to protect the greater public from corrupt unions. I mean, lots of different factors were part of that analysis. And so, again, the rights that are protected, the rights of employees and employers and also to encourage collective bargaining, which we'll talk about in a second, and to curtail certain unfair, inappropriate labor practices, but also management practices. You don't need to know the names of these particular. So let's talk about collective bargaining. What is collective bargaining? This is also something kind of like the right to work state idea that is a source of some confusion for folks. In some sense, collective bargaining is really just like any other contractual negotiation that can happen. Let's say I run a house painting business, and you come to me and you say, I'd like for you to paint my house. Well, there's probably going to be maybe some negotiation. I talk about my cost, the various features that I would do, when I can paint, and there would be a back and forth. Well, I'd want this feature, but not this feature. I'd want you to paint at this time. I can't wait that long, but I can wait a little while longer than that. All of those issues, there'll be a back and a forth and a give and take, and probably we won't end up in exactly the same place that either one of us started at. And there's some unpredictability as to exactly where we'll land. For example, when we start the negotiations, I don't know necessarily that it's really important to you that we finish all the work within 2 weeks. And so we may end up with a date to paint that is closer in time than I would have anticipated. Or it could be that you really don't care when we paint your house. There could be all kinds of dates in the next 6 months that you're fine with. Well, if that's your position, then it's more likely that we'll have a date that's more distant in the future. But I don't know that going in. I don't know particularly what your values, what's especially important to you, and you don't know what my particular concerns might be. And so the journey to the resolution is going to have some surprises and turns and twists along the way. Okay, well, we engage in collective bargaining only after the unions have selected, excuse me, the employees have selected a particular union to represent them. And there literally is an election in the vast majority of cases. Typically what happens is a group of workers in that facility either are contacted by a union or contact a union and say, we're interested in exploring affiliating with you. And then a campaign starts, and it is literally just like a political campaign. There are campaign slogans, there are campaign posters, there are home visits by union members, there is speeches, there is mudslinging, there are promises being made, all the things that you would expect in an election, and a little bit of a, I don't say a dirty election, but it can become a fairly rough and tumble election process. So you can see how the union would be interested in the election, because they're about, if they're successful in the election, they're about to get a lot more customers. So it's, if they're selling a product essentially to these potential members. But who's on the other side? Well, it can vary. Sometimes it's employees who do not support the union who are actively on the other side. But more commonly, it's probably the employer. Most employers would prefer to have a union-free environment. That's not true for every employer, but that's generally the preference that we have in the United States. The perception amongst most employers, maybe it's correct, maybe it's not, but the perception is that having a union tends to limit the flexibility of management. And when management doesn't feel that it can respond as quickly to market forces, then the concern is that they will be kind of left in the dust and not be as nimble and as profitable as they can be. Surprisingly, probably the bigger concern, I know sometimes people think, well, if you work in a unionized facility, you're probably going to earn more money. I don't think that's a major concern with employers, because after all, as we'll talk in a second, employers don't have to agree to any particular term. And so if they don't want to pay more to employees, the fact that there's a union in place doesn't really mean that they're going to have to pay more than they otherwise would for the wages. So during this election period, there's going to be typically about a month where both sides make speeches, have rallies, develop campaign themes, and then there will be an election, and it will be by secret ballot. Employees, people who are eligible to vote, will come in, sign the roster, and then go and secretly vote. After everyone has voted, then the National Labor Relations Board representative, he's called a board agent, opens the ballot boxes and counts the ballots. And whoever has more ballots wins. If it's literally a tie, let's say going back to the example of 100 employees, 50 voted in favor of the union, 50 voted against the union, tie goes to the employer. But if one more person voted in favor of the union, then the whole that whole group is going to be unionized. So you wouldn't have the union represent only the people who voted in favor of it. It's either everybody or it's nobody. Let's imagine a little bit different scenario. Let's imagine that 100 people are eligible to vote, but only 80 do vote. Maybe some are on vacation, maybe some just aren't interested in the topic. Of those 80, 41 voted in favor of the union, 39 voted against the union. So more than half of the voters voted in favor of the union, but less than half of all of the eligible voters voted in favor of the union. Well, in that circumstance, the union still won. It is the majority of the people who elected to cast a ballot. Because of the electioneering and campaigning aspects, this area of the law is probably one of the most interesting areas for attorneys to get involved in. There's almost nothing more compelling than campaigning and debating and exploring all those kinds of issues with the worker. So I encourage, if you have an interest in this area of the law, this can be a very rewarding area. If you happen to find yourself working in a part of the country that is more unionized, especially if the particular facility you're not in isn't unionized currently, you may well have the opportunity as a manager to get involved in these campaigns, because typically the actual frontline managers are the ones who do most of the campaign work. Okay, so we have the NLRB has certified the election results, and we'll say that in this particular case the union has won. Let's first of all say, let's say the union has lost. Well, that means that there is not going to be any collective bargaining because the employees have chosen not to be unionized. And that particular union can't have another election for a whole year. Although another union can come in and there could be an election about that in less time. Okay, so, but let's think about the other scenario. In this scenario, the union has been voted in, and so now we're going through that collective bargaining process. As I said, it's really just like negotiating for any other contract, that there's going to be a give and take. It's just not knowable what the final results will be. Now, unions during the election process will oftentimes make extravagant promises. They'll say things like, we'll guarantee you a 50-cent increase, 50-cent an hour increase, or you only currently get 2 weeks of vacation. You can count on the fact you'll get 3 at the end of the after we've signed this contract. They can promise whatever they want, but they have no ability to provide that. They have to persuade the employer that it is in the employer's interest to agree to these terms. They may be able to do so, but they may not. And so they can't control, because they're only half of the equation. The employer doesn't have to agree to anything that it doesn't want to, and in fact, it won't agree to something it doesn't want to. There is no requirement in our system for the union and the employer to actually reach an agreement. There is no binding arbitration. There is no mediation process, except in the railroad, airline industries. There's some differences there. But in run-of-the-mill industries, if the union and the employer can't reach an agreement, that's okay. Life goes on as things were beforehand. And both parties have the obligation to bargain in good faith. This is a term that you'll see a lot in this area of the law. It doesn't mean that either party has to give up any particular requirement. You know, the union can't be required to give up vacation days. The employer can't be required to pay more money. Any of the terms and conditions of employment have to be subject to robust debate between the parties, but no one has to make any concession that they don't feel is in their best interest. So let's go to the next slide. The agency that manages this process is the National Labor Relations Board. It is the one that enforces that National Labor Relations Act. The NLRB does 3 primary things. First of all, it conducts that election. And it's not just a matter of being the people who count the ballots, but they manage the whole process. They are the election officials, making sure that everyone plays by the rules, and there are a fair number of rules in this process. Then also there's the potential for either side, well, actually all three sides, employees, employers, and unions, to complain about the behavior of somebody else. Imagine for a second that, let's say, out of this 100 worker unit, there are 3 workers who are really the spearhead of this organizing campaign. And one of those workers is, Bob. Okay, so Bob was one of the leaders. He's generally a good worker. People respect him. He's been around for a long time. When it becomes known generally that Bob is supporting the union, that has a lot of credibility. And it just seems like workers that were on the fence, weren't sure if they were going to support the union or not, suddenly start supporting the union because they think to themselves, oh, Bob's a pretty level-headed guy. I like him. If he thinks this is a good deal, I'm for it too. Well, the employer starts seeing that Bob's support of the union is really swaying the workforce. So now the employer says, what can we do? What can we do? We need to stop this. So the head of HR says, let's fire Bob. So that's what they do. They fire Bob. Even though they don't have a good legal reason for doing so, they know that if they fire him, there will be a fair number of employees who will think to themselves, wow, they fired Bob. They must have fired him because he was supporting the union. If I continue to support the union, they might fire me. I don't want to get fired, so I'm not going to support the union anymore. So you can see how it can have a chilling effect upon the union campaign. Well, under those circumstances, Bob and the union would file an unfair labor practice, a ULP charge, against the employer. Similarly, unions can also be subject to ULP charges. Let's say the union threatens people, says, well, we're going to break your kneecaps if you don't vote for the union. Then that employee, along with the employer, can go to the NLRB and say, hey, the union violated the law, committed an unfair labor practice. And these misconducts can actually result in new elections being required or other penalties associated with it. In addition, the National Labor Relations Board, it's an administrative agency, so it also gets involved in rulemaking as well. The National Labor Relations Board, unlike the EOC, the Equal Employment Opportunity Commission, is a very political agency. In the employment area, it is probably the most political. There are 5 members of that board, and 3 are of the political party of the president who is currently sitting. So if the president is Republican, 3 members of the board will be Republican. If the president is Democrat, 3 will be Democrat, 2 will be Republican. As a result, most of the votes of the board are 3-2, whomever is in the majority. And there are actually certain issues that literally get switched depending upon who is the president at the time. When there's a Republican president, for example, wine guard rights are not in place. When a Democrat is president, wine garden rights are in effect. So there are definitely some political aspects. Another thing about the National Labor Relations Board is it's infamous for being very slow to resolve its backlog of cases. And so cases can literally sit through that process for 3, 4, 5 years. And so you can see how it's very difficult. If it's a controversial topic, it's very difficult for you to know how the board will pick because you won't know who will be president then. So you won't know whether the Democrats will have 3 or the Republicans will have 3. So it's hard to know whether to, as if you're the employer or the union, it's hard to know whether to contest that particular issue because it will all turn on whether you win or not on who is the president at that time. And here is our poster again. This is one of the posters that all employers are required to have, both where prospective employees might be present as well as where current employees are. And again, this is one of the posters that would be part of that 12-in-1, I'm sorry, yeah, all-in-one poster. So that concludes our discussion of labor law, specifically unionization. And now at this point, we've covered all three of the big topics of labor and employment law. I hope that this presentation has been helpful for you. If you have any questions, please feel free to email me, come to my office hours, or raise those issues in class. Thank you for your attention and have a wonderful day.